What's going on, everybody? Hope everybody's enjoying their day. Let me turn this phone off, y'all. I'm sorry. Got another phone. So let me turn it off. Or at least turn it on silent or something. Well, let me just turn it off. This is my other cell phone. I'm gonna just go ahead and turn it off. Hope everybody's enjoying their day. My day wasn't too bad. All right, everybody. This will be part 2 Q&A. Let me get that. Let's go to the live chat. Okay. I have my laptop in front of me too, so I'm working on my laptop. Just multitasking. All right, so I'm gonna give everybody some time to get in. This will be where you get all of your questions answered to 42 Section 1983 lawsuits. Anything you can think of, if I can answer the question, I'll answer it. If I don't know the answer to the question, I'm just gonna tell you I don't know the answer to the question. So let's go. We'll stay for about 2 hours tonight, y'all. Give it 2 hours. So if you have any questions, go ahead. What I'm about to do right now is I'm about to post my my ebook into the chat. So if anybody wants to, to purchase a copy of the ebook, it's $10. So I'm gonna go ahead and purchase that in the chat for you. Give me a second. I'm finding the link right now. Y'all give me a second. You can go right here. How everybody doing? How is my audio, y'all? Because I can't hear it, so I don't know how I sound. How is the audio? Give me a thumbs up if the audio is good, or comment or something, and just let me know. Right now, I'm posting a copy. I'm posting a link to my ebook, just to let y'all know. You can click that link, and that will allow you to purchase the ebook. The ebook is $10, just to let y'all know. I made it affordable, and I made it $10 on purpose because I wanted people to be able to purchase it. Thank everybody for voting too, by the way. I know some people wanted, it was about 40% of the people wanted it to start at 3, but I guess, majority rules, you know how it goes. How's my audio, y'all? Can y'all hear me? Like, I can't really see any chat. I can't see anything for real. I'm not sure if the comments are good. What's good, Elite? What's good, man? How is the audio good, man? Because I can't hear it. I don't know. I got my microphone hooked up, but I don't know if the audio is good. Yeah, okay. All right, thank you. Appreciate it. So today's topic is 42 Section 1983. I'm here. Y'all got me for 2 hours. I'm here. All of your questions, I'm here. So go ahead, and I'll do the best that I can to answer. We can get off topic a little bit too. That'll be okay. That'll be fine. I will once the live is done, I'll try to have it up tonight. Once it's complete. Who is this? Okay. Somebody sent me a message. I'm sorry, y'all. So basically, 42 Section 1983. The only thing that you need to, in my opinion, since I've been litigating, the only thing that you need to focus on in 42 Section 1983 lawsuits is the ultimate facts section of your complaint. That is going to determine if this officer or this judge, whoever it is that you're suing, if it's a judge, that shit's damn near impossible. If I were you, I would not even sue a federal judge unless any judge. I wouldn't sue any judge unless you knew that you had them 100%. If not, just go ahead and file a claim against their bond. But anyway, if we're talking about police officers, the ultimate fact section of that complaint is going to determine if that officer is entitled to immunity. They're gonna consider that before they do anything else. They're gonna go straight to the ultimate fact section of that complaint, and they're gonna review those facts and see if those facts are sufficient to show that a clearly established constitutionally protected right of which a reasonable officer would have known about has been violated. That's what they're gonna do. Okay. What exactly? I need y'all to be specific with your questions, because I don't want to get off topic, and I don't want to be too wordy. So, what exactly would you like to know, Elite? Because I've litigated. I call it a win. I would consider it a victory. I got a settlement out of them, so I would consider that a victory. Altogether, it probably cost me, because I was prosecuting the case by myself. So altogether, it cost me about. I don't think it cost me over $800, and I assure you, I got more than $800 back. So, but what exactly would you like to know? The reason why I have my laptop here, so if y'all see me just glancing back and forth, I can't see the comments, because I'm on my phone. I'll be looking at my laptop to see if to review the comments and everything like that. Anything in particular that y'all want to know? If you need the, I have a sample copy of a federal civil rights lawsuit complaint in my ebook. The only matter of fact, I'm gonna post y'all the statutes that you need. I'm about to give y'all the statutes in the live chat box. I'm gonna go ahead and do that right now. Y'all give me 1 second. I think this is it. Yeah, this is it right here. Let's see. Hold on. These statutes that I'm about to post in the chat, these are the only statutes that you need. Now, of course, this would need to be slightly edited to. Looks like I got too much, so I'm gonna have to take some of this out. Hold on, y'all. I'm sorry. I'm gonna have to delete some of it because I got too much in here. All right, let me go back. Y'all give me a second. I'm sorry. Let me see. All right, it's gonna be 3 comments that I post in here. Okay, this will be number 1. You need to allege this statute to show what type of action that you are being that you are prosecuting before the court. So I'm gonna post that one. Of course, like for example, let me go right here. If you're in we see where it says, if you're looking in the chat section, if you see where it says state of Alabama, the only thing that you would need to change is the state. So if you're in Georgia, you would say state of Georgia. You know what I'm saying? If you're in Florida, you would say state of Florida. That's one of the statutes that you need to allege. I'm posting the second one right now. And this is the same everywhere in every U.S. district court. Right here, these statutes right here, you need to allege these statutes. I'm gonna elaborate on what pendent state claims are in a second, because it confuses some people. It confused me also when I started studying this stuff, but it's very easy, just to let y'all know. And venue. This will be the last one right here. These are the statutes that you need. All of these statutes that I have just posted, those are the statutes that you need. You would allege that in your jurisdiction and venue section of your complaint. Pendent state causes is basically state law causes of actions. So, for example, if you're in Alabama. So if you're in Alabama and you want to allege, an unlawful detention, that's considered under state law false imprisonment. That's considered that. So false imprisonment is the cause of action under the state law. So you would simply allege that particular cause of action in the causes of action section of your complaint, if that makes sense to y'all. If it doesn't, let me know. I'll do my best to try to clear it up. But pending state claims are your state law causes of actions. They're federal causes of actions, and there are state law causes of actions. So if they violate the federal constitution, let's say the Fourth Amendment, they violate the Fourth Amendment, then by default, they violate your state law's so-called Fourth Amendment. Do you teach other suits? What type of suits are you talking about? I need y'all to be specific, because I've done, if you ask me, I can pretty much do anything. Non-criminal, okay. Yeah, I do. I've done divorce. I've done numerous divorce cases. Equity, I've never done an equity. An equity suit. I've never done one. I'm quite sure if I study it, I could, but I've never done one, no. Equity is pretty easy. What exactly do you want to know about equity? Suing credit bureaus. You actually can do that. I have to find that statute, but there's a federal statute for that. For suing credit bureaus. There's probably I'm certain that there's a state statute for it too. If you're gonna do it in 9 times out of 10, generally speaking, these cases will be either in the circuit court of your county, possibly the district, or the federal U.S. district court. I've seen the statutes. I have to find them again, but I've seen the statutes to file a lawsuit against credit bureaus in federal court. I've seen those statutes. I mean, it works the same way. Any type of lawsuit works the same exact way. You have to allege your jurisdiction and venue statements, your parties, and your ultimate facts, and then your causes of actions on why you bringing this lawsuit into court. It's the same thing. It don't matter what it is. It's the same thing. Same thing, people. What is that? 1681. Let me look that up and see what that is. Give me a second. Let me see what it is. Why not use public laws instead of statutes? That's a good question. Give me an example of a public law that you would be trying to use. Give me an example. Let me go here. I hope I'm not too close on this microphone. I might be talking so loud. Stats and codes are considered evidence of law. Yeah, I wouldn't even call it law because they're not sovereign, so they can't make law. The only thing I would consider it law over legal entities. It's really public policy. In my opinion, public policy is considered law over fictions, in my opinion. Federal debt. Looks like that practice. That looks like the federal debt collection practice. I think that's what that is that you just cited. Let me see what this statute is here. Congressional finding and statement of purpose. The statute that you cited in the 15 United States Code 1681. Credit reporting. Okay. I've never done a lawsuit like this. If I wanted to study it and take my time to learn it, I can learn that within probably a month, to be honest with you, or less. But it's the same exact thing, man. It's the same exact thing. You have your jurisdiction and venue statement, you have your parties, and you have your ultimate facts. After your ultimate facts, you have your causes of action. After your causes of action, you have your request for relief or your prayer for relief. It's the same, no matter what it is. It's the same exact thing. The same exact thing. Doesn't matter what it is. Let me give y'all there's a website that I use to do my legal research. It's called Case Text. I'm gonna post y'all a link to the website. I'm gonna post y'all a link to the website in the chat section. This website, they charge you for it, but there's a way around it if you know how to do it. But this website is where I get a lot of my case law from. Like if you watch any of my videos and you see me reading cases, I'm on casetext.com reading the case and showing it to you. There it is right here. I'm about to post it right now for y'all. You're in the midst of a suit. Good luck, man. Get their ass. Get them. Don't let them do what the fuck they think that they can do. They think they can do anything. These folks think they can do anything. Y'all give me a second. I'll be right back. I'm sorry. Give me 1 second. All right, sorry about that. I don't believe we should use case law. Became a legislative fact. Case law that's common law. It's judge-made law. So I would agree, in my opinion, that we should, because that's the common law. I don't see a problem with it, as long as it's the opinion was issued in the appropriate context, if that makes sense to y'all. We should study case law, but not cite in paperwork because it's a legislative fact. I would disagree with that. Case law, in my opinion, case law is, all right, look, there are two courts is what I'm getting at. There are two Supreme Courts. Okay, there are two. I know some of y'all probably don't know this, but if you read the Judiciary Act of 1789, they're establishing Supreme Court in that act, and the federal Constitution also established a Supreme Court. So there's two. But case law was binding. It's binding whether there's a legislative act on it or not. To a certain extent, it is. To a certain extent. For example, like the exclusionary rule, for like if they violate the Fourth Amendment, like let's say if they unlawfully detain you, and during that unlawful detention or arrest of you or whatever, they gain some evidence, but the evidence that they obtained from you was obtained unlawfully, and you can file a motion to suppress pursuant to the exclusionary rule. The exclusionary rule that's not from the legislature at all. That's from the judiciary, because the reason why you have the exclusionary rule is because if you have wherever there's a right, there's a remedy, and you have a right to be free from unreasonable searches and seizures. And when they violate that right, they have to give you a remedy. Yeah, you're right to a certain degree, but courts get jurisdiction in two ways. They get jurisdiction either from the Constitution or a statute. That's it. That's the only way that they get jurisdiction. And if they got jurisdiction from a statute, it's not a court. In my opinion, that's not a court. Based on my understanding, that is an agency, and they are adjudicating public policy. That's what they're doing. Judges put on their Article 3 hats when you speak adjudicative facts. I don't know. I probably have to study that some more, but I know this, that if they're enforcing statutes and following statutory procedure, that is an administrative agency. That is not a court. That is an agency, and they are adjudicating public policy. That's what they do. So let's try to focus on the topic for tonight, because a lot of people, I get so many emails. A lot of people want to know how to sue the police. The statutes, I've cited all the statutes in the comment section of this live chat that you need. You would need to simply edit those to a certain degree, and then you should be good. If you allege the necessary prerequisite elements of each cause of action that you are suing, that you're suing this police officer for, you should be good. Judges take, if I'm not mistaken, judges take judicial notice sua sponte, meaning they take judicial notice on their own volition, so to speak. If I'm not mistaken. What is that? Got a damn piece of hairbrush in my mouth. Most lack capacity, Federal Rules of Civil Procedure 17 to sue police. If I'm not mistaken, that's an admiralty rule that you just cited. Rule 17. I could be wrong, but what do you mean they lack the capacity to sue the police? What do you mean? I wish I can. I have to do a blog talk radio so y'all can call in, and we can exchange our opinions like that. I need to go ahead and do that. Not now, but I will do it. But it's not going to be today. But what do you mean they lack capacity? You mean the understanding, the knowledge, to sue the police? That's really irrelevant, because if my understanding is correct, you don't even have to be a U.S. citizen to sue them. If my understanding is correct, because the Constitution applies to everybody who's pretty much over here on the land. If my understanding is correct. Due to citizens being subject. It doesn't matter if you're a subject or not. You still can sue them. You still can sue them, man. It doesn't matter if you're a subject or not. You still can sue them. They are not authorized to violate your rights. I just told you, where there's a right, there shall be a remedy. I've seen cases on that. Where there's a right, there shall be a remedy. And whenever they violate your rights, you have a remedy. And if you don't have a remedy, then you would take it into a court of equity. That was the purpose of courts of equity. When you didn't have a remedy at law, then you would go into an equity court, and you would petition that court for probably like an injunction or something like that. You telling that to somebody who I just told y'all I settled a federal lawsuit. I settled a federal lawsuit. I beat them. 12B6 motions are easy. All that shit is easy to beat. All you have to do is plead facts. Let me show you how you beat a 12B6 is a motion to dismiss for failure to state a claim of relief for which relief can be granted. If you state a claim for relief, you good. And you're going to beat a 12B6 motion. Of course, they're going to try to claim that they got qualified immunity or something like that, but that's why you have to plead facts in the ultimate facts section of your complaint that show a clearly established, constitutionally protected right of which a reasonable officer would have known about has been violated. When you plead facts to show that, it's a wrap. They can file a Rule 12B6 motion if they want to. Their ass is going to lose. The attorney for the police officers who I sued, he didn't file a 12B6 motion. He filed a shotgun pleading because he didn't know how to answer my complaint without losing. He filed a shotgun pleading. He answered the complaint, but it was a shotgun pleading. I whooped their ass. Let's see. No. It would depend, but they would consider that their motion to dismiss. I think it's moot, M-O-O-T. They would call that moot. I think it's moot, M-O-O-T. They would consider it moot. So no. Look, man, this ultimate fact section, like pleading fact, that shit is not hard, y'all. The only thing that you are doing is you are pleading facts, and these facts are relevant to proving why you are suing this police officer for whatever reason you're suing them for. That's all you're doing. That is all you are doing. That's all you, I promise y'all, that's all you're doing. That's it. We can, you really have to catch me. Either you have to book a consultation. If not, then you can catch me on here or Blog Talk Radio. I'm gonna start doing, I'm gonna have to put a number up here next time so y'all can call in and we actually can talk. Like we can talk over the phone and everybody can hear it and stuff like that. But that shit is easy, man. All of that shit is easy. That is easy. But you got to read. If you don't know your rights, then you don't have no rights. You need to go and read case law. You need to go and read constitutional law from common law judges because they're going to tell you what your rights are and what you need to allege to a certain degree. They'll tell you what you need to allege to basically state a valid cause of action in the ultimate facts section of your complaint. Y'all know how many cases I read? Shit, I had to put in hours, weeks, months for this shit. I know when my rights are violated. I know a police officer can walk up to me and try to do whatever, anything. I know if this officer is acting lawfully or unlawfully just by the conduct. Because I know what's a crime and I know what's not a crime. The discovery phase, pretty easy. What exactly do you want to know about discovery? When you are in, a good way to think about it is like this. When you are a plaintiff in a case, you're really a prosecutor. That's basically what you are. You're a prosecutor. You pick all of the evidence that you want to adduce or admit into evidence to support your cause of action. You do all of that shit. They can't file nothing in that case without you seeing it. They have to serve you a copy of every damn thing, or they violate due process when they do that. Sorry about that, y'all. These damn phones, they just don't stop. I tried to turn it off. It wouldn't go off. Discovery is very easy. That's where you get all the evidence that you need. Once you plead facts that show a clearly established constitutionally protected right of which a reasonable officer would have known about has been violated, then you'll go through the discovery phase. The judge is going to look at that complaint And the judge is going to say, well, based on these allegations, as a matter of law, at least right now until discovery is over with, this police officer is not entitled to qualified immunity. That's what they're going to do, just by looking at the complaint. Motions. You don't really file motions during discovery. I've really never seen any motion filed during discovery, except for probably a motion in limine. I think that's the only one. Motion in limine. That's the only one that I can think of. Discovery deals with requests for admissions, requests for productions, interrogatories, subpoena ducis tecum. I might be forgetting something. I think there might be something. There might be some more discovery tools, but I'm probably forgetting them. But it generally deals with those. You should get a copy of the court order. Should tell you that, or your what they call it, a rule. I think it's a rule 26F. I'm speaking in the federal rules of civil procedure. I think it's a rule 26F. Look, once you file a lawsuit and the attorney answers the complaint or whatever, the judge is going to order that you and defense counsel, the attorney who's representing your defendants, the judge is going to order y'all to meet at a certain time, wherever y'all decide to meet. And when y'all go and meet, y'all are going to discuss how many sets of requests for admissions do you get? How many sets of interrogatories do you get? When does discovery start? When does discovery end? How long the trial is going to last? When you need to file certain motions and stuff like that. So I have a case with fictitious conveyance of language. What do you mean? I don't understand that, Alex. What do you mean? They want property taxes for vehicles. Have you ever used Translate versus Plugo? I've heard of that case. What exactly do you want to know about it? If you want to know, can attorneys testify? No, the fuck they can't. Not unless they have personal knowledge pursuant to the federal rules of evidence. No, the fuck they can't testify. If that's what you're asking, no. They can't testify to nothing. Not unless they have personal knowledge. So it doesn't matter what they say. It's all hearsay unless they have personal knowledge. They want property taxes for vehicle. I'm not really sure what's that about, Alex. This is basically in their bill. They use language that is used against us in their bill. What bill are you talking about? Are you using bill as a euphemism for the word complaint or something like that? Is that what you're doing? Is somebody suing you? Property tax bill. I don't study property taxes, and I'm kind of having a little difficulty understanding really how to answer the question. If I saw the paperwork or something like that, I probably would be able to help you. I'm not really sure. Probably. I've never done any litigation in property taxes or anything like that. You bought a new vehicle and in 90 days they want their property tax. You could probably find some case law on that it'll either support their argument to demand, property taxes from you, or it'll support your argument that they can't demand property taxes from you. But you have to know how to do legal research. You have to know what exactly are you looking for. So you can probably go on Google or you can go on Case Text. I posted a link to Case Text. You can go on Case Text and in the search bar on Case Text, type in, make sure you have your state, put your state up there in property taxes in 90 days for vehicles, something like that. You can go to Google. It might be on Google. I don't know. I'm just guessing. Where it's I would say it's different because states are countries, whether y'all know it or not. That's why they have their own flag and their own laws. They're really countries, so it varies state by state. You know, it depends on what your state laws are. There is probably I'm about 99% sure that there is a law library somewhere in your county within at least 50 miles of you. There's a law library there. You can go down to the county courthouse. It's probably in the county courthouse. You can go down there, and it's full of books, full of them. And just open up, or just get on the computer and just do some research. You can case text is like a legal encyclopedia. The link, I'm gonna post it again for y'all if y'all didn't, because I don't know if any of y'all got it. So I'm gonna post case text again. Click that link and go on. Let's see. Go to the top. If you on case text, go to the. There's really nowhere you can do it. You probably have to do it through Google. I'm gonna do something else. I'm gonna give y'all a link to a case. Scroll up to the top. I'm gonna post this link. When I post this link, there's gonna be a search bar on this particular page in case text, and just type something in what you want to know, and it will try to it'll narrow down the case for you. Whatever you're looking for, it'll try to narrow it down, because it's like a search engine, like Google. Let's see. Give me a second, y'all. I gotta make sure my phone ain't dying on me. Okay. What is it? 42, 1986. Let me see what that statute is. I'm gonna see what that statute is that you just cited. Let's see. The claim brought against 42 United States Codes in 1986. Respect to. I'm gonna go on Google and look this up. I need to see what that is, because I've never really seen that statute before. So I'm gonna look it up. Action for neglect to prevent. Every person who, having knowledge that any of the wrongdoers conspired to be done and mentioned in section 1985 of this title. Okay, I see what you're doing. If I were you, I would read cases on this before I did it, just to make sure that you're prosecuting the case right. I would say a U.S. District Court is the appropriate court. That's the appropriate court for it. There seems to be some type of civil action. I've never done a suit like this before. If I studied it, I'm quite sure I could. It says, how to get the court to title my suit as I initiated it. Okay, this is what they do. It's, in my opinion, servant is substance over form. So, like, I can title something a motion to strike. Let's say I titled it a motion to strike, but the body of it, I'm arguing in the manner of like a motion to dismiss. Then based on that, they're gonna basically call it a motion to dismiss despite what the title says, because it's substance over form. It doesn't matter what you call it. It matters what you're arguing, so to speak, if that makes sense. I hope that makes sense to you. But that's basically why it really doesn't matter. It matters what you are arguing. Okay, you're an administrative procedure giving second opportunity to cure. Okay. You're welcome, Alex. I'm sorry I couldn't really help you in regards to that. But if you have a 42 section 1983 lawsuit against, I'm your guy. I'm the one you need to talk to about it. Or you can, hire an attorney or something. What were you arguing? What were you arguing in your case? Thank you, Alex. I appreciate it. Really appreciate it. Servant, what exactly were you arguing? It doesn't matter what you call it. If you're arguing, if you title that a tort, it doesn't matter if you call it a tort action or not. If you title it a tort, but you're not arguing a tort, you're arguing something else, then they're gonna consider it as whatever it is that you're arguing, notwithstanding the title. That's not a tort. I don't think that's a tort. What you talking about? Torts are like an assault and battery. That's a tort, or a violate, like an unlawful seizure of your person. That's a tort. Matter of fact, I'm gonna go ahead and look up the legal definition for tort right now. Yeah, that's kind of vague. I've always known torts to be dealing with a tort is a personal injury. But I've never seen it. I've never seen it argued the way that you're trying to argue. I've always understood torts as like to the body, some shit like that. Let me see. If you want to understand your case better, what I would do if I was you, servant. If you want to understand your case better, go to your local library, pick up an American jurisprudence book or corpus juris secundum, something like that, and go to the tort section. It'll tell you everything you want to know about torts, and that should answer your question. I don't have it on here, but if my understanding is correct, torts deal with the violations of your like your body and your rights. If I'm not mistaken, I don't think it's used in that context the way that you're trying to argue. I don't think so. I could be wrong, but I don't think it's used in that context. Okay, you were injured personally for their false reporting. Okay, I'm not sure what the cause of action would be against them for their false reporting. I answered your question. They changed the nature of your suit because what you were arguing, and you just not understanding it. That's why they changed it. They basically told you without telling you what you need to do or what type of action that you had without telling you that, unless they told you expressly in the paperwork. Yeah, they what is this? 5-star photography and 5-star weddings. Let's see. You'll probably never get that from them 5-star. I really don't know. I'm gonna start trying something like that too because a certificate of title is not ownership. Oh, okay, I got you, Alex. Got you. A certificate of title is not ownership. A legal title is ownership. No. Well, they do have a right to decide that based on the facts of the case. But what I'm telling you is this: whatever you argued in that paperwork, your complaint, it doesn't seem to be what you thought it was. So they changed it to the appropriate cause of action. I'm trying to put this stuff in layman terms. If you ask me, that's what it seems like they did to me. I mean, that's what it seems. Yeah, to me, based on what you're telling me, that's what it seems like that they did. If you want to, I can send you my documents, and you will have a better idea. Honestly, Alex, I don't even really have time, man. Like going over stuff like some of this stuff takes it takes hours. Sometimes it takes weeks, months. Just doing the legal research. Now I'm pretty good at doing legal research, and I'm pretty fast. But once I find the research, I like to take my time to make sure that I can fully comprehend what I'm doing and how to argue the case. And that shit takes time. So like that's why I always tell people, like, if you really want me to help you, I'll help you, but it takes time. And I'm gonna charge you for my time. Because that shit is mentally exhausting. I'm not gonna lie, that shit is mentally exhausting. Can I send you my pleading? Yeah, honestly, Servant, you better off just scheduling a consultation, man. I try to be affordable. Because I don't really just do this for money, but of course I want to be compensated for my time. So I try to be affordable, which like $50 an hour, $25 for a half hour or something like that. I'm trying to come up with a way to where I can do it. I would say cheaper, but I'm just trying to make what you're paying for more effective, if that makes sense. That link you talked about, right, is a paid service for legal research, right? Yeah, Alex, that will be correct, but there's a way around it. If you hit the link that I sent you, it was about I'm gonna post the link again. I'm gonna post it again. All right. If you click that link, Alex, when you click on it, a case should pop up. There should be a search bar on case tick. It say something like search all cases and statutes. That is where you type the information that you want to know about. That's the way around finding the case that you want to know about and reading it. Telegram. I probably should create a Telegram. This is the second time somebody told me that, but man, I'm in Telegram groups right now because I do. You're welcome, Alex. I'm in Telegram groups right now because I trade in cryptocurrencies too, and these damn Telegram groups go all night. So I don't really know if I want to do that. Shit it's mentally exhausting. Y'all give me a second. I think I'm sick. I don't know why. I feel like I'm getting sick or I got a cold or something. Just give me 1 second. I'll be right back. Oh boy. All right, y'all. I'm sorry. Sorry about that. Drop a link for consultation. Where is it? I think I'll give you my email address. My email address, my PayPal email address. Give me 1 second. I'm gonna post it in the chat. And I'm gonna post my Cash App too. All right, the first one is that's my, like, if you have PayPal and you want to use PayPal, you can send PayPal or whatever, just so you know your purchase is secured. It's insured, so to speak. And my Cash App is the same thing basically. Alex, have you clicked that link, Alex? And have you typed anything in the search bar section of that link? Okay, good, Alex. That's where I get a lot of my legal research from. Like, Alex, if you go on there, let's say you find a case, and let's say it might be very, very similar to your case. That case, you would probably see an argument in there in support of your argument, and you can just copy and paste that argument into your paperwork. They're gonna narrow these issues down for you on this website, and they're gonna cite the authority for why they're doing what they're doing in these cases on here. If you use once you figure out what they're doing on case text. I just got out the shower. I hope I don't get sick. I got my heater on, but do y'all have any trust? I know a little about trust. What exactly do you want to know? Trust law, commerce. I know a little. I've been studying. I really don't have time to study like I want to, but I really want to because I want to draft my own trust. I want to buy some land, and I'm gonna put it in a trust. Put everything in a damn trust, and I'm gonna make myself the trustee, the beneficiary, and the settler. Because you can't do that. Actually, matter of fact, just show y'all. I don't want y'all to think I'll be lying about shit. I'm at my office desk right now. Y'all give me a second. Let me see if I got it. Here it is right here. This is the book. This is the book that I was reading on trust. Just to let y'all know. I think this is a pretty good book. So I'm gonna move my hand so y'all can see the title. I think that's a pretty good book. I got this book from I think Books A Million. I think that's where I got it from. I hope y'all can see it. That's a pretty good book, y'all. That's a sham trust. A sham trust? What do you mean that's a sham trust? You can do it if you hired a foreign trustee. You don't have to do that. Based on that book, this book that I got was written by attorneys. That I just showed you, it was written by attorneys, and they don't say anything like that. Yeah, I'm not gonna be the only trustee or beneficiary of this trust. I am gonna be the settler, and I am gonna be a beneficiary. And it's gonna be an irrevocable trust. I'm not gonna own it, but I'm gonna control it. Just what Yusuf was saying. Yusuf was right. That like I said, that book that you see me that I just showed, that's that book was written by attorneys. That doesn't mean that they all so smart. But anyway, I'm also gonna do my own research too, because sometimes I make mistakes. I'm not right all the time, so I'm gonna do my own research as well. All right, sir. But I'll check it. I won't do it. I won't do it tonight, but I'll check it out. Matter of fact, let me look it up right now. I'm sorry. I'm gonna go ahead and look it up now. Let's see. Yeah, if based on this definition of sham trust, you would be inaccurate. This is what it says. Sham trusts are trusts in which a settler does not actually intend to distribute any assets, but rather intends to create the impression that the assets have been disposed of. No, I'm going to actually be distributing assets to myself and another beneficiary. The settlement of the sham trust will create the impression so that they can maintain actual control of the trust. Now, this is going to be an irrevocable trust. It's going to be irrevocable. I'm just going to draft the trust in my favor because I am the beneficiary. So I'm going to draft the trust in my favor and in all of the beneficiaries' favor, who I make beneficiaries of the trust. That's what I'm going to do, which will basically be my offspring. You can play all three, Rob. Well, I'm not going to argue trust. I'm going to focus on 42 Section 1983. No offense. No offense. Probably talk about trust another time because I don't want to get off topic too much. But I will take what you're saying into consideration because, like I just said, I don't know everything. I do make mistakes sometimes. But as of right now, I'm convinced that I'm right. But I will do some research and just double check from time to time. Yeah, no problem, man. We all make mistakes sometimes. No problem. So do y'all have any like federal lawsuits as far as like for violations of your constitutionally protected rights? Any questions like that? I'm gonna be here for, let me see, I've been on for probably about an hour now. I'm gonna stay for about another hour. Statutory remedies are just that. They're remedies that are derived from statute. Equitable remedies are they're remedies that were given by courts of equity, or so to speak. Equity would be, if I'm not mistaken, I think equity has much so to do with doing what's just, what's fair, and what's right. So I think equity is like probably doing, I would call that probably doing God's work or something like that. They're trying to, you're trying to be fair. I think you need to go back and read that. So because I really think that they probably threw you a bone for real and trying to, because sometimes they'll do that. They'll try to help you out. You know, they'll read over it and based on their expertise, they'll decide um, the nature of your suit and if it's proper. They'll do that. All of them ain't bad. I ain't speaking up for them now because some of these motherfuckers are terrible. Some of these judges are terrible, and they think they can do whatever the hell they want. I had a judge tell me one day in court, he didn't give me permission to speak. I don't know why the fuck he said that to me. One, I don't give a fuck about going to jail. I don't want to go to jail, but I don't give a fuck about going to jail. And if you give me a lawful purpose, it's a problem. If you give me a lawful purpose to defend myself, because I'm going to do that. I don't care if you're a judge or not. But anyway, he told me he didn't give me permission to speak. And I looked at that motherfucker and I said, I don't need your permission to speak. That man recused himself right there in that courtroom, and I ain't seen his ass no more. I've never seen him again. So they violated my rights. Who violated your rights? You talking about the court? Because they changed the name. I just told you it's substance over form. It doesn't matter what you call it. It's always going to be substance over form. It matters what you're arguing. Doesn't matter what you call it. It's just like you going in the kitchen and you say, I'm gonna make a red velvet cake. But you don't get any of the ingredients to make a red velvet cake. You get all of the ingredients to make a German chocolate cake or a pound cake or a cheesecake or something like that. And you still want to say that that it's a red velvet cake. You see what I'm saying? I'm not trying to make fun of you or anything like that, but I'm trying to give you an example or a metaphor so you can understand what I'm saying, because I understand it. I understand what the court. I didn't even need to read your paperwork, but I understand what you were trying to say. Says how can something we create tell us, the living being, what I can file under? Because you're in an administrative court. Not only that, like, if there's a remedy at law, you'll get your remedy. If there's a remedy in equity, you'll get your remedy. If there's a remedy in admiralty or whatever, you'll get your remedy. That's if there's a remedy for it. But you're in a statutory court. You're in an administrative agency, and they get all of their authority from Congress. That's what they do. They get their authority from Congress. So certain types of cases they can hear, certain types of cases they can't hear. But I think you misunderstanding me. Okay, it seems to me that you were arguing something else. You weren't arguing what you thought you were arguing. So the court considered what you were actually arguing, if that makes sense. Man, when Alex, when they're telling you that you can't speak in a courtroom, they're telling you that they basically violate due process, because the only way that they can take away, your right to speak is through due process. That's the only way that they can take your life. That's the only way that they can take your property. You see what I'm saying? It's due process. So he's arbitrarily taking away your right. That's basically what he's doing. Man, I don't give a look. We can get physical, or I don't care if you're a judge or not. Like, if you give me a lawful purpose to defend myself, then I'm gonna do that. I don't care who you are. Sir, but I'm not saying that you're incompetent. I'm not saying that. So if that's how you're construing that, I do apologize, but that's not what I'm saying. I'm telling you that it is substance over form. It does not matter what you call it. It matters what you are arguing. That's all I'm saying. Let me see. Does your YouTube have an option to bring in other people? You're misunderstanding me. I don't know, sir. It may, but I really don't know. I have to try it out. I really don't have time to do it right now. I've never really done it, so it will probably take me forever to try to learn how to do it. Because I've never done it, so I really don't know. No, Alex, I don't have a Telegram. I mean, I have a Telegram account, but like I said, I do crypto currency. I invest in cryptocurrency, and I am in Telegram groups for different types of cryptocurrency. I've been thinking about doing a Telegram group, but I don't really know, because that damn cryptocurrency group, the notifications, they don't stop. They just all night. Like they are constant. Like it's like 25,000 notifications or something. I don't have time for that. I'm sorry. I don't have time for that, man. Um, all right. Well, we'll try to I'll try to next week. I have a number so you can call in, so y'all can call in and we can talk over the phone. And I try to live stream from my cell phone, which is obviously what I'm doing right now because my damn laptop. I have to get another laptop, but just to try to make it convenient for everybody. Telegram. I might, Alex. I might. I would have to see how it would be beneficial, for y'all in regards to the lawsuits. I've done divorce cases for people. Um, I've done criminal cases for myself. Of course, I lost some criminal cases. I didn't know what the hell I was doing. But like right now, they'd have a hard time making charges stick against me right now. I just beat 3 traffic tickets a while ago. I've been stopped with numerous active KPS warrants by sheriffs, state troopers, all that, and then all of them let me go. One of them looked me dead in my face, told me I think he said I had about 8 or maybe 10 KPS warrants or something like that, but he's not taking me to jail or something like that. But I'm getting all that stuff taken care of. I'm about to expunge my record anyway. I've never done an expungement, but I'm 100% certain that I can do it. So I'm giving it to expunge my record. I can draft any type of motion, any type of appeal. Sort of, writ. I can draft writs. All of the stuff is easy though, y'all. All that stuff is easy. So let me see. Do y'all have anything about like the ultimate facts section of the complaint? Any questions about that? Because everything that's the only thing that you need to worry about is the ultimate facts section of that complaint. Because everything else is just copy and paste with very little editing. Everything else is just copy and paste. You need to make sure that that you file it in the proper court. Make sure you serve your parties. Make sure you keep all receipts of anything that you pay for regarding the case, so you can get reimbursed for that. Speak on elements. Okay, servant, what type of elements would you like to know? Because different causes, like a cause of actions, different causes of actions have different elements. In other words, facts or ingredients. So an assault and battery cause of action would have a different set of facts than one for, let's say, malicious prosecution. They will have different set of facts. So what you need to do is you would need to go and read cases. You would type in, one of y'all give me an example. What type of cause of action that you would like, for example, like false arrest, unlawful detention, assault, battery, excessive force, whatever. And what I'll do is I'll look up a case while I'm sitting in front of my laptop, and I'll copy and paste the link to the case in the group, and then y'all can go and read that case. In that case, whatever case I type up, that I copy and paste into the group, it's going to have the elements that you need to allege in your complaint to state a valid cause of action for whatever it is that you're suing for. Elements are they just facts, ingredients necessary that you need to plead your case. That's basically it. That's all elements are. Violation of public law. Let me see what that is. I'm gonna see what this is, servant. Hold on. Okay, if I were you, servant, me personally, I would just go and read cases on this stuff, and these cases should tell you the facts that you need to allege in the ultimate facts section of your complaint. I really don't read statutes because they're kind of vague to me. Some of them they're just so vague they don't really give me a thorough explanation, or so to speak. So what I do is I just go and read cases that are that are explaining the statute and explaining the purpose of the statute, the scope of the statute, shit like that. That's what I do. Satisfaction of threshold elements. Affiant have shown first, second, third, and fourth defendants failure to follow reasonable procedures in injury, that the injury was caused by what does that mean? I don't know what that means, servant. Like, what are you copying and pasting your something from your complaint? Is that what you do? I really don't know what any of that means. When you are pleading facts, you can't. It seems, I could be wrong. Okay, I could be wrong, but based on this right here, what you just pasted in here, it seems like you're not really pleading facts. You're only alleging conclusions, and you can't do that. You have to allege facts. Okay, you have to allege facts. You cannot allege conclusions without facts in support of those conclusions. They call those conclusory. If you're going to read, if you're going to watch my video, I think I did 2 of them. It's All About the Facts, Part 1 and Part 2, where I'm talking about how the police officers, they do the same shit when they trying to procreate criminal charges against you, and they do it in a conclusory manner, not a factual manner. They don't have any facts to support it. They just say that you unlawfully did this. They don't explain how you did it and how they came to the reasonable conclusion that it was unlawful and so on and so forth like that. They do that shit all the time. That's why people lose in 12B6 motions to dismiss, because they don't plead facts. They plead conclusions without facts in support of those conclusions, and you can't do that because you violate due process when you do that. And they do it all the time. All the time. You can allege conclusions if the agency has defaulted on your administrative process. Yeah, I honestly, servant, I really don't know what you're talking about. I'm not saying you don't know what you're talking about. I'm saying I don't know what you're talking about. So I can't say you're wrong. I can't say you're right. I really don't know. I'm getting hungry. Any questions on federal lawsuits? If you want me to expound, I guess, more on the statement of facts, let me know. I don't think I can expound on it any more than that. What I'll do is I'll give an example. I'm gonna give y'all an example of what I mean. Uh, I sent the agencies 3 notices verified by notary, the acquiescence. So therefore, I allege conclusions. That would seem to be correct, but again, if I've never seen the paperwork, and I really don't know the nature of this lawsuit. It seems that I'm guessing you're talking about the credit reporting, but let me go ahead and look up y'all the case. And what I'll do is I'm gonna post a link to the case so y'all can go and read it. So I'm gonna look up something for an assault and battery. That's what I'm gonna do. So we're gonna say assault and battery. I'm gonna say elements to assault and battery. Cause of action. Okay, I found one. It is looks like it's Gordon versus Culpepper. So what I'll do, I'm gonna post this case. Give me 1 second, y'all. Give me about 15 seconds. Hopefully, yeah, there it is, right there. I'm about to post y'all this case. Matter of fact, I'm gonna copy and paste the citation. Hopefully, it should fit. If it's not too much, it should fit. So y'all give me a second. I'm gonna post the law, and if you want the case, let me know, and I'll post the case. This is excessive force. Here we go, false imprisonment. I'm almost there, y'all. Give me a second. Malicious prosecution. Okay, we have one for malicious prosecution. Here it is, right here. We can do this one. Hopefully this will work. Okay, right now I'm about to post y'all a case citation with a case law that tells you the elements that you need to allege for a assault and battery. All right. Damn it. I might not have enough space, y'all. I don't. Damn it. I'm gonna have to delete some of this. There's not enough space. So what I'm looks like I'm just gonna have to. Well, let me try something out. I might. Damn it. All right. This is what I do. I just posted something to the live chat, and I'm gonna post the case citation for it too, so y'all can go and read that. You see how it says it's giving you the elements that you need to allege a cause of action for malicious prosecution. That's what these cases do. That's why I keep telling y'all to go and read the cases. Let me see if I can find another one that's shorter but more descriptive. This probably ain't gonna be good enough. Now I'm going over. I ain't gonna be able to. Okay, it's too long. I ain't gonna be able to post this one, y'all. It's too long. All right, so I'm gonna go ahead and just post the case. If you read this case, this will give you an example of what I'm talking about. Alex, I would go and read this case if I was you. If you still watching, Alex, I would go and read that case if I were you. Just click on it, read it. It's going to give you an example of what I mean. So when it says, I posted one for malicious prosecution. You see where it says the elements of the common law tort of malicious prosecution? 2, an unlawful seizure in violation of the Fourth Amendment, and 3, that the unlawful seizure related to the prosecution. So basically, those are the elements that you need to allege. And if this is vague and you don't understand it, all you have to do is just go and read cases. That's all you have to do. Or you can go to the law library, get you an American jurisprudence book or corpus juris secundum, something like that, and go read the cases. You can be assaulted without anybody even touching you. Based on the cases I've read, you can be assaulted. All right, y'all, we got looks like about 28 more minutes before I end the live. So what we got? What we got, ladies and gentlemen? What we got? Who are you? Who did you file that tort action against, servant? You saying it's a tort. Who did you file it against? No, what agency? I should have been more precise with what I was asking. What agency did you file that tort action against? Federal CRA. I don't know who the hell that is. Let me see what my battery is, y'all. I don't want my phone to go dead on you. We got time. We good. The credit agencies. Okay. I don't see that being a tort, man. That's probably I don't see that being a tort. But anyway, I don't know. What are the elements or claims of a habeas corpus? What have the court said? Okay. Let me see. Give me 1 second, Romeo. I'm gonna look it up for you. If I'm not mistaken, you only file a habeas corpus petition if you believe you are being unlawfully detained or imprisoned, if I'm not mistaken. But I'm gonna go ahead and look up some cases so I can give you some more details on it. Let's see. Let's see. Give me one second. I'm still looking it up right now, man. Let's see. This is a writ. It's gonna look like it's gonna take me some time. I don't want to spend too much time on it because I don't want to, bore y'all. But trying to find this. On the facts of the petition clause. He is. What is that? RC chapter prescribed the procedure. I tell you what. What state are you in, Romeo? And I'm gonna look it up that way. I'm gonna look up the there's got to be a statute somewhere on it. If I'm not mistaken, I know what the habeas you challenge the sufficiency of your incarceration or your detention, if I'm not mistaken. You're right. There must be elements. The elements. Okay. Let me go. All right. Give me a second. I think I know the elements, but I don't want to misquote nothing. So that's why I'm trying to find the case. Trying to find it. This is gonna take some time. I don't want to spend too much time on it. So what I'll do, I'm gonna cite a matter of fact, they have a damn a form on a habeas, like a PDF form or something like that. I'm gonna give you I'm gonna post this link to the a sample form of it. I'm gonna post this link. Hopefully this link will help you. I don't want to spend too much time on this, but that's not really the topic of the show for tonight. It's 42 Section 1983 law. Click that link, Romeo, and that link should help you. But generally speaking, you would file a petition for writ of habeas corpus challenging your imprisonment or detention, if I'm not mistaken. And you would basically plead facts on how your detention is unlawful or your imprisonment is unlawful. That's That's basically, if I'm not mistaken, I think that's what it is. So if you believe that, that you in prison, without probable cause, you file a habeas. For example, I would file a petition for a writ of habeas corpus if I was taken to jail because I told the police, fuck you, and they took me to jail for disorderly conduct. I will petition the circuit court in Alabama for a writ of habeas corpus, and I would allege all of those facts in support of in support of that habeas. I would tell the court on such and such day, blah, 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 I'm being held without probable cause under these set of facts, such as the police officer took me to jail for disorderly conduct for telling him fuck you or some shit like that, if I'm not mistaken. I think that's what it is. I have cases on it, but I don't have the time to look at it, to look for it, because I don't want to spend too much time on it. No substantial delay, good cause, or 3, fundamental miscarriage of justice, elements of habeas corpus. I've read something different than that, so I don't know, sir. I've seen something different than that. I don't think I know they need good cause. They need. Let me rephrase that. They need probable cause. Unless good cause means probable cause, they can't just take you to jail for no reason. They have to have probable cause, which is a mixed question of law and fact. So if they do that, then you can write a petition for a writ of habeas corpus on a fucking napkin in jail. Did you click that link, Romeo? I think that link will help you. That I just posted in the chat. This seems like looks like this is very similar to a Rule 32 in Alabama. This PDF file that I posted in the group seems like it's very similar to a Rule 32 petition. What y'all got for me, man? Y'all got me for 2 hours, man. I got about 26 more minutes right now. Let me see. Inadequate basis for detention. 2, removal to another federal district court. The denial of bail or parole. 5, claim of double jeopardy, failure to provide for a speedy trial. Or the legality of extradition to a foreign country. Okay, that kind of sounds more like grounds for a petition for a writ of habeas corpus. I think I would agree with the second one that you just posted. And when it says inadequate basis for detention, removal to another federal district court, the denial of bail or parole. I don't know, that might be a due process claim, a claim for double jeopardy. It might be a habeas thing too. I don't know. I might, if y'all want to know about the habeas corpus petition, what I do is I just look up a whole bunch of law on it, and I just go live one day, and then we'll just do a live Q&A on habeas corpus. We can just do it like that. But all of this stuff is easy, man. It's facts and elements. Romeo, you're right. It's facts. That's it, man. Once you plead facts to show that that writ should be granted, generally speaking, then the writ should be granted. you don't have, just to let y'all know, you don't have to. You can petition for a writ of I mean, not a certiorari, pretty much any writ. But anyway, you can petition for a writ of habeas corpus without a statute. Just to let you know, when you're doing it, when you're using statutes, you are you're petitioning the court in an administrative capacity. When you're not using statutes, then you're doing it under the common law. And if you're gonna do it without a statute, then you need to petition. You need to file that petition in the circuit court. If you're in Alabama, you need to file that petition in the circuit court because the circuit courts have general jurisdiction. Alex, they ain't gonna let you do that. They not gonna let. In my opinion, ain't no license to practice law. It's all bullshit. Ain't no license to practice law because one, ignorance of the law is no excuse, and everybody is presumed to know the law, and you can't practice law. But they telling you can't practice law without a license. It's just bullshit. How you gonna tell me that I can't practice law without a license, but ignorance of the law is no excuse, and everybody is presumed to know the law? That shit don't even make sense. You see what I'm saying? It just don't even make sense. Alex, it would depend on what type of case it is. But I would tell you this, always, 100% of the time, in all criminal proceedings, demand, don't ask shit. Make sure you file paperwork. Demand to know the nature of the action. They're not going to tell you that, but just demand it. Because they're supposed to tell you. When they don't tell you, they violate due process. And when they violate due process, they lose jurisdiction. Because I just told y'all earlier in the video, where there's a right, there's a remedy. So the remedy that you get when they violate due process is they lose jurisdiction. Maxims, they just principles. Case laws are principles. So it really doesn't matter. It's the same shit. Case laws are principles. Maximums are principle. It doesn't matter. It really doesn't matter, for real. Let's see, for helping your mother. What is it? Let me see. Is it a criminal case, Alex? Or is it civil? Romeo, that might work. You get a power of attorney, that might work. But like these judges, they so goddamn corrupt, man. They just, you can be 100% right in your arguments, and they'll deny your motion or whatever. They won't tell you why, because they don't want to give credence to your paperwork. They haters, man. They some real haters now. I'm telling y'all what I know. They haters. Insurance lapse, and they want $800 to reinstate. Shit. I don't know. She might be under some type of contract or something, Alex. I really don't know. I wish I could help you with that, but I really don't know. I don't want to, give you the wrong advice or whatever. So I really don't know, Alex. Yeah, they'll deny your demand for a bill of particulars, but they can't. I don't go for what they do. They can't violate due process. They can't violate due process. They will, but they can't, and they lose jurisdiction when they violate due process. They have to tell you the nature of the action. Yeah, do y'all know why they're supposed to tell y'all the nature of the action? How many of y'all know why? Yeah, JL, that sounds about accurate. They'll do that, but they violated due process when they did that. Yeah, Alex, it is in the Constitution. That's right, Alex. But there's another reason why it goes into more. It's more in depth than that. That is servant. That is not why they denied his motion. That is not why. You will be wrong. No offense, but you're wrong. That is not why. The reason they denied it is because they don't want you to know the nature of the action. They don't want you to know that it's admiralty jurisdiction that the case is being prosecuted under. That's why. Well, they didn't do that they didn't do that in none of my like in my federal lawsuit. I mean not Alex server. They didn't do that at all in my case. And I cited case law all through my shit when it was necessary. And they didn't pretty much deny. I think in my motion to strike some of my arguments they were denied, but they denied them because what did the judge say? He said he was going to treat them as there was case law in support that he was going to treat them as denials instead of disputes. It was something. I would have to read that case. But anyway, long story short, my motion to strike was granted in part and it was denied in part. Give me 1 second. I'll be right back, y'all. I'm sorry. All right, y'all. Sorry. I don't know. Something keeps just getting in my throat. I'm sorry about that, y'all. Nature and cause. Let me see. If you can't have power of attorney and the person has an attorney on the case, it has to be one or the other. Some of y'all are kind of hitting the hammer on the nail a little bit. Some of y'all are, but I think I don't think Alex really knows, so I'm gonna go ahead and tell y'all because I don't think Alex knows why you need to demand the nature of the action. Nature means like origin. What's the origin of the action? What jurisdiction is this action being prosecuted under? So there were 3 jurisdictions. It's 3 or 4. I know there's cases at law, equity, admiralty, and maritime. So that's 4. Okay. So there are only 2 criminal jurisdictions though: admiralty, which is quasi-criminal, and common law, which is really criminal. So each of these jurisdictions were in different courts. So courts of law, common law courts, they had their own courts. Equity courts had their own courts. Admiralty courts, maritime courts, they had their own courts. So each of these courts, because they were in separate buildings, they also had their own rules of procedure. So if you were in a criminal court, if you were in a common law and it was a criminal action, then you would proceed to the criminal rules of procedure under the common law. If you were in an admiralty court and it was a quasi-criminal proceeding, then you would proceed to the rules of criminal proceedings under admiralty. Hold on. Give me 1 second, y'all. Let me read. I'm trying to read these comments. When they violate due process, they lose jurisdiction. They not gonna tell you this shit. They gonna act like they don't know what the fuck you talking about. I'm telling y'all what I know. They gonna act like they don't know what the fuck you talking about. So when they start doing all this shit, the way you make these people leave you alone is you have to cost them money when they start violating due process. Now, you can report them to the Judicial Inquiry Commission, because if you're in Alabama, there's an Alabama Judicial Inquiry Commission, which is I think it's in Montgomery, and they sanction judges. You file a complaint against that judge. It works just like when you file a lawsuit. You file a complaint against a judge, they'll read your complaint, see if your complaint has merit. And if it has merit, then the Court of Judiciary will, I think they're gonna set a hearing, or they're gonna file a complaint against the judge. It's something like that. And long story short, the judge is gonna get a trial, so on and so forth. They will sanction the judge if they feel like that there's a reason to sanction the judge. They can remove that judge from office. They can fine that judge if necessary. But me personally, I would just contact risk management, file a claim against their bond. I don't have time for this shit, because you can't sue them, because when you sue them, it's almost impossible to sue them because of judicial immunity. You can do it, but it's almost impossible. That's just how difficult it is to sue them. You can possibly go after them in a criminal proceeding. Risk management. You can you can go to Google right now, Alex, type in whatever state. Let's say if you're in Georgia, you would type in state of Georgia risk management or something like that. And it should pop up. That's where their bonds. The bonds are going to be either with risk management. Okay, well, you type in South Carolina risk management. Type in that, something like that. The bonds are going to be either with risk management, the Secretary of State, or some type of probate court or something like that. That's where they are in Alabama. Excuse me. But all of the judges' bonds in Alabama are going to be with risk management. They have because Alabama, the judges and prosecutors, they're covered under the state's blanket bond. And you get that bond from risk management. They don't have their own separate bond, is what I'm getting at. Like the probate judges in Alabama, they have their own separate bonds. I have a copy, just an example. I have a copy of a judge's bond. I'm gonna show it to you. I'm gonna see if I can find it. Hopefully it's still on here. If it's on here, I'm gonna copy it and put it in the chat section. It looks just like damn insurance, some shit like that, because that's what it is. It's actually insurance. Let's see. It might not be on here. I think I might have saved it on a flash drive or something like that, and I don't know what I did with it, y'all. No, I don't think it's on here. I think I saved it on a flash drive, and I might have deleted it, or it's on another computer or something. I'm sorry about that, y'all. But yeah, that's where you can find the bonds at. Yeah, but anyway, let me get back to the I kind of got off track. I'm sorry about that. So the reason why you want to demand, Alex, the reason why you ask for the nature of the action is because all of these courts that I just mentioned, courts of law, equity, admiralty, and maritime, these were separate courts. And all of these courts had their own rules of procedure. Okay? So what they did was they have merged all of these courts into one court. Okay? And since they did that, they've merged all of those rules together. They've condensed all of the rules. So you don't know which rules governs the proceedings. So you don't know which hat the judge is wearing. Also, you can impeach them before the legislatures because they operate as legislative courts and not judicial courts. I would agree with that, Romeo. I would agree with that. I don't think you can, you might be, I don't know, because the judges in Alabama, they, like circuit and district judges, the people vote for them, So I would think you may can impeach them through the legislature, but I know the Alabama Judicial Inquiry Commission. I know that they can remove them from office and fine them and sanction them and all that shit. I know that they can do that. So, but I would think that you were right, Romeo. I would say that you're right about that too. They will not want to give you the nature and cause. How do you stand your ground to get it? I'm gonna go ahead and tell you this right now, Alex. They are never gonna tell you the nature of the action. They never, ever, ever, ever going to tell you that they are operating on admiralty jurisdiction. You can forget about that. They'll tell you it ain't common law. I had one judge tell me it wasn't common law. They ain't gonna never tell you that ever. But there are ways that you can find out the nature of the action. But it's not that's not your burden. They're supposed to tell you the nature of the action so you can determine which rules govern these proceedings. And when they don't tell you the nature of the action, they'll say some shit like it's statutory jurisdiction. Statutory jurisdiction is a euphemism for admiralty jurisdiction. Go and look at that video that I posted on here that says, there's a video I posted that said common law bonds versus admiralty bonds. And I'm showing you that they don't call them admiralty bonds. They call them statutory bonds because they don't want you to know that it's admiralty. Go look at that video. When I get some time, I'm gonna do a video on. It's gonna be in Alabama. It's gonna be based on the Alabama code, and they're gonna have all of the bonds in there. Like appeal bonds in Alabama, and all of these bonds. I bullshit y'all not. I've read these bonds. All of these bonds are in the nature of admiralty. These are admiralty bonds, and these are the same bonds that you use to appeal and get out of jail, and what is it? When you pledge your property or you a recognizance bond or something like that. But in admiralty, they just worded them different or whatever. I'm gonna show you all the comparisons. These are admiralty bonds that they're using because they are operating under admiralty law. I posted a case law that says admiralty courts are civil law courts. Civil law is statutory. Civil law is dealing with statutes. Yeah, you can, but they'll just ignore you. They don't want you to know this shit. They don't want nobody to know that they operating on admiralty jurisdiction. They don't want nobody to know that. But I guarantee you, I'm 100% sure that they know it's admiralty, and they're not going to tell you. They are not going to tell you that. You can forget about that. But if you want to know the nature of the action, the plaintiff always picks the nature of the action. Always. The plaintiff always picks the jurisdiction because it is the plaintiff that has the authority to request a specific type of relief once she or he has alleged facts in support for a court granting that relief, if that makes sense. Yeah, these are administrative courts. They need your permission to do any damn thing because they're administrative agencies. Let me rephrase that. Article 3 courts need your consent to do anything, but they get your consent. They construe, like when you file anything in court, they construe that as you conferring jurisdiction on them to act. Because you are a court, whether y'all know it or not. In Black's Law Dictionary, there's a definition for the word court, and it says the person and the suit of the sovereign. You are sovereign, and your lawsuit and your person makes you a court. You are a walking court. Yes, the fuck you are. But they're not gonna tell y'all this shit, man. Y'all can forget about that. They're not finna tell y'all this. They just ain't. I would agree with that, Romeo. They operate like military courts because if you ask me, man, I could be wrong. I need to do some more studying on this, but I believe that the word civilian, I think they use the term civilian in times of war. I think that term is used when a country is at war. Like when you go to like when soldiers go to another country and they call them non-combatants or civilians or some shit like that, but they're actively in war over there. What I'm trying to tell y'all is I don't think the terms citizen and civilian are synonymous terms. That's what I'm trying to tell you. I don't think those are synonymous terms. The reason why I say that is because admiralty courts are civil law courts. Civil law is dealing with statutes, civilians. If you are a civilian, you are not sovereign. I don't see it. Maybe I'm misquoting some of this stuff. I probably need to do some more research because I don't want to misrepresent anything to nobody, and I don't want anybody to I guess get in trouble about something that I've said or something like that. So I think I'm gonna do some more research on that. Criminal court. I would always challenge the jurisdiction of that court. I wouldn't even wait. I wouldn't waste no time. When I file paperwork, I don't file nothing in there in the capacity as a citizen. I go in there as the state. I am the state. I am the state. I am an extension of the state's sovereignty, and so are you. When you see the word state or Alabama, when you use the word Alabama, like I use the word Alabama in my paperwork, I am Alabama. There is no Alabama without me. I am an extension of Alabama's sovereignty. What constitutes a state? People constitute a state. You take away the people from every so-called state, and what the fuck do you? You have nothing. You don't have nothing. So I plead in my sovereign capacity. This is my court. This court, because everything is held in trust. All of this shit is a trust. Everything is held in trust. The land, the water on the land, the fish in the water on the land, the roads, the courthouses, all of that shit is held in a trust. That's why these people are public servants. They trustees. The Constitution is a trust. What documents should you have prepared for criminal court? I'm gonna get off in a little bit, y'all. I'll probably stay on about 10 more minutes and then I'm gonna go ahead and leave. What documents should you prepare? Me personally, I think I would probably edit this document. There's a document that Yusuf talks about. I think it's the affidavit of sovereignty or something like that, an affidavit of truth or something like that, where you are basically pleading away their jurisdiction because you're disputing all of their minimum contacts against them. I would use that document. I would probably edit it, to make sure I knew what I was doing, to make sure that it fit my case. And if you want to add some stronger arguments in there or something like that. But I filed the document to the end to know the nature and cause of the action. That's what I filed that document. And I beat 3 traffic tickets, something like that. JL, I would file affidavits. Affidavits are, in my opinion, affidavits are a must. That's if you go if you really want to litigate this case. Yusuf teaches a different method. I don't, I'm still trying to learn Yusuf's method, but I litigate. I'm not gonna let these motherfuckers do nothing. But anyway, I will file an affidavit. Once they in default, I probably file a notice of default. Make sure they get, what is it called? Certified mail or something like that. Get a signature on it. Make sure that they got it. Then, get it time stamped in the court from the clerk's office. Depending on the action, I will file a motion to dismiss for lack of jurisdiction. Violation to do it really depends. I can't really answer that question without knowing like what type of case that they filed against you. You see, people of the state of. Do y'all know the term people is used in singular and plural? I am a people. I'm one of the people. They changed your status. That's what the fuck they did. I am one of the people. Who the fuck are you to tell me that I'm not sovereign? They know you. I guarantee y'all, if y'all think I'm lying, see if you can get these people to admit in a court of record that you're not sovereign. Just ask their ass and see if you can get them to admit that on the record. If they telling you that you're not sovereign, then they basically telling you that they in public office either unlawfully or shit. It just doesn't make sense because you had the authority to put them in that public. They voided the whole Constitution because in order for you to create this Constitution, you have to be sovereign. In order for this state to exist, you have to be sovereign. You sovereign. They ain't gonna tell you this shit out their mouth. Go read these cases though. I cited cases that's showing y'all that you have a right to a revolution. Whenever you feel like that your rights or your liberties are under threat against a tyrannical government, you have every right to a revolution. Because you sovereign. And I don't want to tell y'all this shit. If you were not sovereign, I promise you, they would not need your permission to amend the Constitution. They would just do that shit whenever the fuck they wanted. But they can't do that because they are not sovereign. And they limited by the Constitution. Now the people, whether y'all know it or not, or whether you believe it or not, the people right now, the people can just say, you know what? We don't like this Constitution because y'all just not acting right. So what we gonna do, because you motherfuckers are not acting right, we're gonna tear up this Constitution and we're just gonna write a whole nother. The people in every state, whenever the fuck they want, can do that whenever the fuck they want to. Because the Constitution does not apply to them. It applies to public servants. The people can tear that damn Constitution up right now if they want to and write a whole nother one. Whenever they want. Because they sovereign. Pull up chapter 9, meetings section. Let me see what that is. I'm gonna get off here in probably about 5 more minutes, y'all. Give me a second, sir. Let me see if I can find it. Romeo, did that link that I posted to you, did that help you? I think I know what you're talking about, sir. But I mean, I don't need to do that. No offense. Because when you understand sovereignty, you should understand the principles associated with sovereignty. The people are sovereign without subjects, meaning they don't have slaves or people under their authority or whatever, so to speak. I mean, of course, I would disagree with that because obviously my people were a while back, they were slaves a long time ago. But that I don't want to talk about that. But anyway, no disrespect to the ancestors. But anyway, you welcome, JL. Let's see, what time is it? Okay, I got about 5 more minutes, and then I'm gonna get off here. I'm gonna I don't really need to do that. Let me see. I'm going to look. I'm going to look at after I leave the chat. Let me see. All right. Let me see if I can. I'm gonna see if I can find it. Server. 'Cause I saw it, but I don't. It looks like it's meetings. Which section? Let me see which section. I think you put a section in the chat. Let me see. 449.50. 449.50. There it is right there. Okay. Yeah, I think I know which section you're talking about. I'll go ahead and read it. It says, the people of this state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. So yeah, I mean, you're sovereign. That's a principle of sovereignty. That's why I didn't want to read it, but I understand why you wanted me to read it. But you sovereign. You are sovereign. Yeah, I'm going to read these cases if you want whatever. But listen, I really don't want. I don't like getting off topic, y'all. Okay, I'm gonna upload this live tonight once I get off. I don't like getting off topic. So next time, if y'all don't mind, please, let's just talk about 42 Section 1983 lawsuits. Now, if y'all want to discuss other topics, let me know, and we'll do that. I'll do a live on that, just to try to do my best to educate y'all the best way I can. You're welcome, sir. No problem, man. What was I gonna say? I forgot what I was gonna say, y'all. I'm sorry. That'll be the end of this live, y'all. I'm gonna go ahead and get off here. I hope everybody enjoyed their evening. If you have any more questions, you can post them in the under this video, and I'll try to answer them whenever I can. Okay. Sometimes I get busy, y'all. So I try to answer them whenever I can. I'll try to go live again sometime next week. I'm not sure. I probably go Monday or Tuesday. I'll try to go live, and we'll do it like that. If y'all have a subject that y'all want me to talk about, let me know. And I'll do some research on it. I'll pull up some cases on it, and then we'll discuss it. That'll be the end. I hope everybody enjoys their evening. Thank y'all. I appreciate your time. Peace.